name is Jane Moore, and I use she, her pronouns. And I'm a white woman with my hair pulled back. I have glasses, and I'm in my mid 60s with kind of brownish hair. Thank you for joining. This is our third in a series for in recognizing Disability Employment Month. We did the two prior two Wednesdays we did them. One had to do with vocational rehab, and one talked about generally our I just got a notice about breach. Sorry. We talked generally about what our advocacy services are for DRM. Briefly for me, I've been here with DRM about eight and a half years. Prior to working on the employment team, I worked on the mental health team. And of note to this specific training, I worked right after the ADA passed at the University of Illinois at Chicago, sort of bringing in the disability services and checking for ADA compliance. So this is kind of something that I miss it's dear and dear to my heart. So Lauren, my co-presenter.
Thanks, Jane. Hi, everyone. My name is Lauren Willie. I'm the legal director at Disability Rights Maine. My pronouns are she, her. I'm a white woman. I have long brown hair. I'm wearing my reading glasses, which are sort of new to me. And just so Jane has far more experience, I think, directly working with these types of services. But I have been with Disability Rights Maine for almost 9 years now, and I'm very excited to be able to present this to you today.
And thank you, Lauren. And she's underestimating her knowledge and experience. So we're lucky to have her with us today.
So just our standard disclaimer that this educational training is for education only. It's not meant to take the place of specific legal advice to anyone here. We're happy to answer anyone's questions to the best of our ability, but we're not in a position we're going to be able to give legal advice. And we're also going to be giving you information on, current laws and things that affect reasonable accommodations in education. And, everyone, I hope, is aware that laws sometimes change. So what we're talking about today is true today, and it is the responsibility of people to sort of double check to make sure that what we're saying today is still applicable in the future. Oh, so sorry, this is my slide. So just a very brief sort of overview of Disability Rights Maine and who we are. So our mission is to advance justice and equality by enforcing rights and expanding opportunities for people with disabilities in Maine.
And Disability Rights Maine is part of a national network of protection and advocacy agencies. Real quickly, the protection and advocacy system came out of an expose and unearthing the conditions at a hospital in upstate New York called Willowbrook. The conditions were horrible. It was children at that point with developmental disabilities that were institutionalized there, and it kind of led to the exposure that has created this protection and advocacy system. There's one in every state. We also have them in every territory, including in Washington, D.C., and as well as there's a tribal protection advocacy agency in the West. So there's 57 of them, and every state designates the agency, and Disability Rights Maine is that designated agency. And we were founded in 1977. We have a nonprofit. We're a nonprofit. We have a volunteer board of directors that it's required to have 51% of the board must be people with disabilities. We're the only cross-disability advocacy organization, and we do operate statewide. We go all over the state. We have people in different parts of the state as well. So some of our key priorities, first and foremost, is our elimination of abuse, neglect, and exploitation, and that's especially in facilities. And that was the first thing. Yes, that's the bedrock priority of ours. The other ones include reducing the use of guardianship, improving access to disability-related supports and services, including access to due process, increasing access to competitive and integrated employment, which is kind of the team that we're on here today, challenging housing discrimination, and increasing access to inclusive education. And this is also something we're working on. This is part of today's presentation. And finally, as the election comes next week, we're ensuring access to voting for people with disabilities. I'll just leave it there. The priority areas are how we guide our case selection, which is the process too. So our services in general are information and referral, and everybody who calls will have an intake, and we'll meet with someone usually for at least a half hour or probably just a half hour. And then that case is then provided to mostly the managing attorneys who look it over and see what and if we can help that individual. Minimally, you're going to get some information. It could be a referral to an agency that can handle what you've asked about, or just information, general information about the situation that you're facing. But it also can lead when you call and do an intake to individual advocacy. And that's usually when you have an advocate assigned or an attorney who's going to work with you to on not in the courtroom or anything like that, but try to advocate for whatever your situation, your rights, and make sure that you have access and to what you're looking for. It could go to the stage where it's legal representation, where you're going to have an attorney assigned to you, and you will have an attorney-client relationship. So those are what happens when you call for specifically for your own individual situation. We also do a lot of training, such as today, and I want to just say that if anybody wishes to have us come train on any issue other than, this, including other things that we might be offering, please feel free to reach out to our number. We really like to assist people with their own self-advocacy. Not only does that develop skills for the future, but it really helps, it empowers the individual, makes them feel they did this and it's better all around. And finally, we do outreach and monitoring, and the monitoring is specific to typically to places in institutions or group homes like that. It's a kind of it's a formal process that we use. And outreach, which we've been at fairs all summer. We've been at places that we hope we can reach people with disabilities or friends and family that might tell someone about us and they can call us. And here's how you request assistance. You call to schedule an intake, or you can scan the QR code, or you can look online at our website. It's drme.org. And there's an online intake form that I've been told it works very well. So we look at those daily. We take the calls daily, so it's responded to in a pretty timely fashion.
So I'm going to go over the slide. This is really what we're going to be covering today. So today's plan is to go over what are the laws governing accommodations in post-secondary education, what are reasonable accommodations and how do they differ from post-secondary education versus earlier education. What does the process look like and where do you start? What kind of supportive documentation should be gathered and how should it be submitted, how to maintain an accommodation, and what happens if things don't go according to plan. So we're hoping that people can come away with this some real sort of concrete idea of what to do when you need to request or maintain an accommodation in a post-secondary educational setting. Next slide. So yes. Oh, this is you. Sorry, go on, Jane.
That's okay. So post-secondary education includes education and training. We thought it was important to define this. Today we're talking about post-secondary education, which is education institutions or training at 2 or 4-year colleges and universities, but also career training, the trade and technical schools that provide important skill training for individuals. What we're not doing today, but we don't want to minimize that, is post-secondary transition into employment. We're not going to talk about that today, but we will certainly available calling or whatever to give you information about that. Primary, vocational rehab and your high schools can really help with that transition as well. But today we're just going to focus on post-secondary education. And now it's Lauren.
Sorry, got carried away. So we're going to do I'm going to do a brief overview of what are the laws governing post-secondary education. So next slide. Next slide, please.
Yeah, I'm trying.
Oh, okay, sorry.
Let me go because I have my mic off. Okay. And now it's not letting me go at all. Oh, there we go.
Okay. So first, let's talk about a couple of federal laws. So there are federal laws and state laws. These are laws that are passed by the federal government. So two of the really big laws that cover post-secondary education is Section 504 of the Rehab Act of 1973 and what I hope many of you have heard of, the Americans with Disabilities Act, the ADA. So Section 504 of the Rehab Act, this was a federal law passed in 1973. And this law basically says that for any entity, and today we're specifically talking about educational programs, so any kind of educational programs or activities that receive federal financial assistance, if they're working on grants or federal funding, which includes most post-secondary institutions. It means that for those entities, discrimination is prohibited. Discrimination based on disability is illegal. Um, Similarly, the ADA, which was a law that was passed in 1990, which is shockingly recently considering all that it does. The ADA was sort of a law that was modeled on the earlier Section 504 that I just talked about, which, by the way, Section 504, also passed in 1973, was really the first federal anti-discrimination law for people with disabilities. And that law has a really cool history that I will not go into today, but I would just advise everyone to sort of look into the sit-in that people did to get that law really enforceable. Anyway, and the Americans with Disabilities Act takes that prohibition on discrimination and applies it in other circumstances. So the law has one section called Title II, and that applies to all public institutions. That includes all public colleges and universities. Title III applies to private entities, things that are owned privately, not by the government. And that applies to all private institutions like colleges and universities. The whole ADA basically, again, prohibits discrimination based on disability. And it does a thing that's called requiring reasonable accommodations or auxiliary aids. So this is where really the basis for the idea of reasonably accommodating people comes from the ADA. Next slide. So that was federal law. So I'm going to talk for a minute about Maine law. This is a law that our state specifically has passed. And in Maine, we have our anti-discrimination law is called the Maine Human Rights Act. This prohibits discrimination for all sorts of reasons. Disability is one of the protected classes that discrimination is prohibited. It also prohibits discrimination based on gender or race or ethnicity. But today we're talking about disability discrimination. So the Maine Human Rights Act protects people against disability-based discrimination. It has a broader sort of definition of disability than the ADA does, but it does do something similar. So it just sort of gives more protection for people with disabilities in Maine. It also requires places of public accommodation. So that's places that are open to the public, such as colleges and universities and post-secondary schools, right? Um, that's all covered under the Maine Human Rights Act. It's also covered under Title III of the ADA. So that's just a really long way of saying that there are protections both in federal law and in state law that prohibit discrimination based on disability in colleges and universities. Um, so one other law that, this is a federal law, that protects people with disabilities is the Fair Housing Act. And that basically prohibits discrimination in places that are housing. This is relevant to educational settings because dormitories are housing. And so the Fair Housing Act also protects people that live in dormitories or other student housing facilities. And it has broader protections than the ADA, particularly with regard to emotional support animals, which in Maine are called assistance animals. Housing has to, generally speaking, has to allow people that have assistance animals to have their assistance animals live with them. They're not considered pets. Okay,
Fine.
next slide,
There we
please.
go.
Sorry, I'm just checking, keeping mindful of the time. So the Rehab Act and the ADA, and I think I probably mostly talked about this already. So again, the Rehab Act, which is the federal law, prohibits discrimination from any entities that receive federal funds, and they have to allow people with disabilities meaningful access to their programs and activities. we're going to be talking a little bit more about what that means as we get into like sort of what accommodations are. And the ADA similarly requires reasonable modifications or accommodations to make sure the whole idea behind all of these requirements for meaningful access and reasonable accommodations is to ensure that people with disabilities have the same opportunity to use these services, to be educated as anybody else, anybody that doesn't have a disability. There should be equal access. And so that's really what sort of the underpinning of these laws are trying to do. Denying someone a reasonable accommodation or denying someone the opportunity to meaningfully access these programs is discrimination. Um, and so I'm going to turn it over to Jane for the next slide.
Now we're going to get into the nuts and bolts of requesting accommodation in post-secondary education. First, let's define the term. Reasonable accommodations and modifications are requirements that schools must modify the policies, practices, and procedures or the provision of services to allow students with disabilities to enjoy equal opportunity at education. Auxiliary aids and services are communication aids that enable effective communication for students with disabilities. Now, schools don't have to provide accommodations or auxiliary aids that they show is constitute a fundamental alteration of their programs or services or an undue burden. And we're going to discuss those later, but let's talk about reasonable accommodations themselves. As Lauren was kind of saying, it's all about leveling the playing field. This is not a special privilege. This is not something that the person with a disability is getting a pass on something. It's really just leveling the field so that they can access, or people with disabilities can access the same thing that people without disabilities can, which is an education and opportunity. And it's not just in the classroom too. It goes on into extracurricular or other aspects of education that one has at school. So I just like this title. Total title is not mine, but someone is a book that's cited there. It's like, Toto, I have a feeling we're not in high school anymore. There are big differences between K through 12 and post-secondary as to how they accommodate people with disabilities. In K through 12, the overall thing is to provide a free, appropriate public education, and that's sometimes referred to as FAP or FAPE, that ensures the student's success. In post-secondary, yes, equal access to programs and services and education is part of the law, but it's not guaranteed. You are not guaranteed success. You're not getting, like I said, just equal access, and again, you graduate, that's it. So in K through 12, your school is responsible for identifying students with disabilities, and arranging services. That is not the case in college or high school or post-secondary. You must disclose your disability and request the accommodations. It becomes you become the advocate for yourself in a very direct way. In K through 12, the school provides evaluations and documentation at no cost. In post-secondary, the student is responsible for obtaining this documentation, and we're going to talk about documentation in a second. In K through 12, the school must provide all necessary accommodations, modifications, and services. And again, there's in the post-secondary, because of the laws that are there, they don't have to provide services that fundamentally alter the academic program. So those are key pieces. A lot of this we're going to cover as we go on, but it's important to, if anybody is working with, or you are a person transitioning from K through 12 to post-secondary education, it's really important to know that the shift goes to the responsibility shifts to the person with the disability.
Can I add something before you go
Sure,
into the next slide?
absolutely.
Um, just because the no cost bit on the first part caught my ear, and it's true that sort of while when you are younger, when people are younger in K through 12, the evaluations and documentations must be provided at no cost to the person to sort of identify what the accommodations are. I also want to make it really clear that the cost of the actual accommodations, whether it's K through 12 or post-secondary, or they can't be passed on to the person with the disability. So for example, and we're going to go through some examples of possible accommodations, but say someone needs a note taker or something like that, to just give a general example. A school can't be like, of course we'll grant your accommodation for a note taker. Feel free to hire whoever you want and you are responsible for the cost. Costs of accommodations can't be passed on. The documentation or whether you need to pay for your own evaluation. That might be a different question, but the accommodations themselves shouldn't, the person with the disability shouldn't bear those costs.
Yeah, thank you, Lauren. That's a really important point. So requesting accommodation on campuses, I think it's really rare enough to find a campus that doesn't identify a disability office either, or at least a representative, a coordinator. So when a person gets to campus, they need to find out who that is, because that's going to be key to the steps of requesting an accommodation. Once that is identified, you should also look to see if there's procedures that you need to follow. Do you have to put something in writing? Do you have to give your documentation right off the bat? What are the procedures that need to be followed in order to request an accommodation at schools? Um, I looked on some websites of schools. Um, Granted, they're some of the larger schools that I looked at, but they have that all on their website too. So I think because the law has because the ADA had passed in 1990, I think finally people are taking note that they have to make this accessible to people with disabilities. And that also this has to be in at whatever communication is needed for an individual to be able to access this as well. So it had the ADA, the disability coordinators in the process to request accommodations need to be accessible. If it's on a website, that website needs to be accessible to someone who uses a screen reader and things like that. Probably gonna, at least initially, you're gonna have to meet with the coordinator. And that's an important meeting because actually, so much is in writing that they get to interpret, but here's a chance for you to speak out or an individual to speak out about what works for them, what they need and why they need it. Um, so that's a really good opportunity to advocate for oneself. And the key to this is to make sure you start this process early. There's deadlines that schools have. Now, whether those are hard and fast, I don't know, but I think importantly to get the process going earlier so it's less stressful too. Like you have them in place from the first day one, because having a accommodation that you need come in after 3 weeks of classes can be pretty stressful. So I think that's an important piece. So your question, like, how do I know if this accommodation is necessary? You might have had stuff in high school through a 504 or IEP plan, but you don't really know what college is going to be like if you're first starting out, if you're making that transition. Um, well, talk to people. Talk to the disability coordinator. They can help figure out what types of accommodations might work. Especially, in your freshman year, you're not sure what the classes are going to be like. I remember being in a huge lecture hall, the professor way down at the bottom, barely could see him kind of thing. I went to a large school. What kind of accommodation would work for an individual there versus something a small like seminar type class where you're like all sitting around tables. So you need to speak to the disability coordinator because they're likely to know what the classes are going to be like. And I'm sure, hopefully, they've had experience of accommodating other people. Not that there's one size fit all. I want to, everybody's individual. So every accommodation will be individual to that person. And if you're working with vocational rehab, they can help with transitioning in school. Vocational rehab is a good resource for accessing education. And so they might be able to help in terms of identifying accommodations that are necessary and that work for you. Lauren.
So we're going to talk about disclosing a disability and how that fits into requesting an accommodation. And I think what I want to say at the outset is just very basically, in order to qualify for a reasonable accommodation, you have to have a qualifying disability. And that's not usually, I'm not going to get into what that is really too much because that's not usually what the issue is, right? Does the person actually have a disability? Um, you have to, though, be able to show a connection between the requested accommodation and the disability. Um, and you have to be able to show that the accommodation is necessary to make it fairer, right? To eliminate the unfairness that's created by, I was going to say the disability, but I actually would submit that the unfairness is actually created by the policy that's making it unfair for the person with the disability to access the services in the way that everybody else can. So that's what you have to show to get an accommodation. I have a disability, this policy or procedure, or way it's being interpreted by the college, the university, the dorms, et cetera, the extracurriculars is making it more difficult or impossible for me to participate or use these services because of my disability. And this accommodation is going to fix that. Okay, so that's what you need to show to get an accommodation. So the first thing you sort of need to do is explain that you have a disability. Disclosure is necessary to receive disability-related accommodations. Once you disclose a disability, it is illegal for someone to treat you unfairly because you have asked, because you've disclosed a disability or asked for a reasonable accommodation. If someone turns around and says, you know what, you're kicked out of school because you even bothered to ask, that's illegal. It's also not supposed to be a particularly burdensome process. So it's not, there are things that obviously a person has to do to request the accommodation and documentation, and I'll get to that in a minute about that they might be required to provide. But you shouldn't necessarily need to have a lawyer represent you. You should be able to do it with um, ease. And as Jane explained, like the civil rights coordinator or the disability services office at the university like, should help you through that process. I also want to say, in disclosing a disability to ask for an accommodation, people are not required to share their entire medical history with the college, the university, the coach, whoever they're requesting the accommodation from. So if the answer is, well, please sign this medical release so we can call your doctor and have a conversation and ask anything we want, and your doctor has to answer, that's not allowed. You really have to just disclose enough to demonstrate that you have a disability and that the accommodation is necessary and related to the disability. So if someone's asking you to share way more than you're comfortable or you think is necessary, feel free to sort of question those questions and those requirements. Um, so,
Is that okay?
oh yeah.
Okay.
So I said I talk about documentation, and so I'm going to talk about documentation. So again, you don't have to give everything, but you do have to demonstrate some um, burden that you need this accommodation, that somebody needs this accommodation. So these are just some examples of documentation that would be helpful to provide. So the recommendation or a letter from a qualified professional, a letter from a doctor, for instance, saying this person needs this. Again, it doesn't need to share everything about your medical history. But it should say, this is what this person needs as a doctor or a medical
Sorry.
professional. I agree that this is what this person should be accommodated in this way. You can show proof of past accommodation. Say in K through 12, you had accommodations, you had a 504 or an IEP plan. Which are plans to accommodate students with disabilities. So showing past accommodations is another way to document. Observations by educators, either at your current school or your previous school, results, of psychological evaluations or other types of evaluations, a history of a diagnosis. Or a student's own statement saying, here's my history and here's why these accommodations would help me. So any and all, and this isn't even probably the full list of things that would be helpful. But in order to convince a school that you need an accommodation, you have to show some sort of basis for it. And so some of these examples are documentation that you can consider.
So this is really important, I think, for individuals to know because unlike high school, you say you've had an accommodation for your first year in school, freshman or your first year, training to be an electrician. No, it's not automatically continued to the next year. So you're gonna have to talk to someone and review and maintain the accommodations. You're gonna have to, I don't think there'll be as much required of you to show that you need the accommodation, but you have to make it a point to meet with the ADA coordinator or whoever the disability offices to talk to them that yes, you're going to need it for this. And there might be new accommodations you might need. Maybe this semester you're going to be in a lab, so you might need new accommodations when you didn't need them last time. So it's important to look at your next year, the individual look at the next year and see, well, these classes are a little different, so I'm going to need something else. But also some of them are the same, and I'm going to continue to need the accommodations I had for last year. So important to know that it's not an automatic renewal and no one's going to say, hey, didn't you have this last year? You're going to have to make a point to have the accommodations maintained. So what kind of accommodations are there? So we're talking a lot about them. So here's some examples. This is by no means exhaustive. There, there's as many accommodations as there are people probably going to school who have disabilities. First, as we are seeing today, sign language interpreters are a key one for people who are deaf or hard of hearing or have some language difficulties. Same for real-time captioning. And all this can be, I mean, school, like Lauren said, this is the responsibility of the school. So if you are deaf and you have a lecturer, they must provide you with a sign language interpreter. And so it's a really, and that, as you might know this, that costs money, and it costs money every time you're in class, but that's their responsibility. Real-time captioning, another way to access the lecturing. Note takers, that a lot of people ask for note takers, and I think it's a great accommodation for people. And usually it's either another student in the class, so it's not really a hardship at all. I've sometimes it's someone else, but usually it's another student in class who takes better notes than they might have taken and provides them a copy to the individual. You might need some ergonomic and accessible workstations, or like depending on, or a desk or something like that, depending on where you're at in your education and what you need. That could be also if you're doing something like becoming an electrician, or that those there may be accommodations that are needed there. That should say extra time on tests, not extra help. Because extra time is, I don't know what extra help would be, that sounds, but maybe extra time is extra help, right? So individuals may need a little bit more time because of whatever the disability makes it hard for them to complete the test in that hour as a result of their disability. So there has to be that tied to the disability. So if I'm a wheelchair user, I don't know if I could argue that I need extra time on a written test, but I might need a desk that's accessible. So it's different for different disabilities, but that's a common one too, is extra time on test. A quiet testing area. Sometimes you get these tests and you're like right next to people or in the room, and you hear people get up to do whatever. And it's hard to, if you, it's hard for me to concentrate. And if a disability affects your ability to work in that kind of setting, you could ask for a quiet testing area. Extra time for assignments. And again, these have to have what they call a nexus. It has to be tied to your disability. But extra time for assignments for some individuals, it will be an accommodation for their disability. Test readers is another one. Having some kind of course attendance flexibility is something you might, I can't think of an example offhand, but that's another type of accommodation that could work. Some modified breaks. You perhaps need to leave a classroom for 10 minutes and come back in. A reader for exams. I guess that's kind of, I had that over there. I'm
Hmm.
reading this now saying, oh, wait, that's a duplicate. Classroom location changes. Now, when I was working at the University of Illinois Chicago, it is a historic campus, a lot of old buildings, and they just don't have elevators. So if an individual needs to be able to get to a course, they have to make that classroom available. That they have to make that. So if the course is usually held on the third floor, but there's no elevator, and an individual needs to get into the classroom, and can only do so on the first floor, that classroom has to change. So you register and you can ask, look, this classroom's on the third floor. I can't get to it. They need to change the room. So that is the responsibility of the university. And of course, auxiliary aids and services to help in effective communication. So those are just some examples. I'm sure Lauren could come up with 10 more, but right now that we want to keep going, but those are examples that come up. And if when we have time for the questions and you want to ask, is this something of course, everything's specific to the individual, because we can't ever say yes or no, but it's something that might be something considered. We can just talk about that. So
Can I add something before we go on? Because we have plenty
absolutely.
of time. Um, so when I'm looking at some of these examples, the term for it is escaping me right now, but there's this concept that like accommodating people with disabilities helps everybody, right? This isn't necessarily like curb cutouts, right? Those little sort of dips in the curb are useful and necessary for people that use wheelchairs, for instance, in order to cross the street. But they're also helpful for people pushing strollers with children in them. So like some of these, like the ergonomic and accessible work desk, right? If there's a classroom that has an ergonomic seats for everybody, that's good for everybody. That's
Right.
certainly necessary if someone needs it, for an accommodation that has a disability. But a quiet testing area, things like that. Like a lot of these accommodations help everybody. So while there might not be necessary for everyone, they certainly make access to education easier for everyone, even though they're necessary for some people.
And a quick example is when I was working, someone was a note taker for an individual and they gave them the notes and everything. And they said, I have never taken better notes in my life and it's helped me so much because I had to take really good notes to be sure that individual had access. So that individual realized that the job that they were given, it helped them too. So that's kind of the same idea.
A great one. Um, so what is reasonable? Because perhaps you've noticed that the term reasonable accommodation requires an accommodation to be reasonable. So it's a very lawyerly answer for me to give you, but what is reasonable is not necessarily a very black and white test, right? It depends. But nevertheless, we're going to give a few examples and sort of things to be considered, because in order for someone to qualify for an accommodation, besides them having to have a qualified disability and there being a connection, the accommodation also needs to be reasonable. Sometimes it is easier for us to talk about what's not reasonable than what is reasonable because there's so much more of what is reasonable in my mind. So let's talk about a couple of what they're called defenses to um, colleges and universities denying someone a requested reasonable accommodation. I will also say before I get into this, there's also a sort of this requirement of what's called the interactive process. So if someone asks for an accommodation and a college or a university says no, that's not the end of the story. They're required to sort of go through this process with the person to say, well, we actually can't provide what you're requesting, but what about this other thing? So it should be a process. It's not necessarily just a question with a yes or no answer, and then that's the end of it. Um, so that said, what is not reasonable? So the law gives a couple of big categories of things that are not reasonable. One is what's called a direct threat. Something, if the accommodation poses a direct threat to the health or safety of others, that could be determined to not be reasonable. You know, I'm trying to come up with there's just extreme examples in my head, but let's say somebody asks for an accommodation. I can't even imagine how this would be related to a disability, but I have tuberculosis that's actively contagious, and I still want to be able to come to class. Um, that's probably going to be a direct threat because it's going to, put others' health and safety at risk because tuberculosis is highly contagious. So that would probably be something that'd be considered a direct threat. That's not considered reasonable. Something that makes a substantial change to the essential element of the curriculum, or what we call a fundamental alteration in the manner in which someone provides services. Um, Again, I'm trying to think so the accommodation changes the very nature of the thing that is being requested. So let's say it's an extracurricular activity. It's a soccer team. It's a university soccer team. And a person requests an accommodation that says, I actually can't play soccer. I'd like it to be chess instead. We all play chess. Like that would probably be a fundamental alteration of the program. These are very extreme examples. I just want to say that these are not examples we see being requested. I'm making up examples to just show that what these kind of concepts are. So something that's considered a sort of fundamental alteration of a program would not be considered reasonable. Another type of defense against providing a reasonable accommodation is something that poses an undue financial or administrative burden. um, for example, usually elevators where they don't exist already are considered an undue financial burden. And I'll give you an example how the interactive process plays in and tie it back to Jane's example of changing a classroom location. So let's say someone's taking a calculus class in university and the class is on the second floor of a very old building that does not have an elevator. If a person who uses a wheelchair wants to take that class and they ask for a reasonable accommodation for the building to install an elevator, that might be found to be an undue financial burden. And the university might say, That's not a reasonable accommodation. It's not reasonable. We can't do that. But it doesn't end with the no there. They have to engage in the interactive process. So that might mean a different kind of accommodation that's not an undue financial burden. Maybe that means moving that class to the first floor or another building that does have an elevator or an accessible way that a person with a wheelchair can access it. They might allow remote participation. I'd be concerned about that because I don't know that that's considered equal access, but my point is there's a lot of other things that might be considered if a request places an undue burden on the entity being requested.
Can I just add
Um,
something there, Lauren, real
yes,
quickly?
please.
So one thing that when you're working in this field, what they say is you're requesting an accommodation to get to the end point. You may not get the Cadillac for the accommodation, but you might get the Volkswagen. And I'm not saying that the Cadillac wouldn't be the best thing, like the elevator would be the best thing probably for everybody involved. But
Mhm.
the idea is that you're actually the classroom being moved is what you were looking for, being able to access that classroom. So you may not get what you think is the best thing. And but I say fight for it. But if you can't get it, be able to be willing to settle for something as long as the access is the same, as long as that's going to give you the same access. And I just, based on my experience at the university, the actual change of the essential element of the curriculum, the educational viewpoint, was the one that most professors brought up. It was lowering the academic standards. They had a whole array, even though 504, 504 had been existing for years. When the ADA came in, everybody paid attention all of a sudden. And that was the number one complaint of faculty is that you're lowering the academic standards. And it's
Mm.
really too bad that that is the number one complaint. And they didn't make an attempt to try to understand. It was just accessing. It was the access. It was not changing anything. Sorry, Lauren.
No, and that's an excellent transition to our next slide, which is a little bit more about fundamental alterations. Good. So Jane's absolutely right that a fundamental alteration can't change the academic standards for a program. It's not required to make an entity is not required to make changes to the essential parts of a curriculum. Um, Courts have found that's requiring a school to lower standards through modifications or provide new programs or new curriculum would be fundamental alterations. Um, but I want to just make a point here that I think this is an important point to make because I think that there are many, shockingly many people, I think, that should know better that consider reasonable accommodations to be favors or special treatment. And this is the biggest response that we get to requests for a reasonable accommodation. Well, if we let you do, if we did this favor for you, we have to do it for everybody. I want to speak to both of those points. Number one, a reasonable accommodation is not special treatment and it's not a favor. It's required by all the laws I talked about earlier to allow people with disabilities to have access to all of these educational opportunities. So it's not a favor. It's discrimination if you don't do it. Um, it's also, I also just more than I expected get the well if we allowed you to do that if we gave you more time on this test we have to give everybody more time. That's not true. That's exactly why we have the laws allowing reasonable accommodations to make things equitable, to give people who are unfairly sort of denied the right to equal opportunity to level the playing field, right? So if somebody doesn't need extra time on a test, they shouldn't get extra time on a test. So that's what an accommodation is. It's an accommodation for one person. It's supposed to be very individualized. And just by the very nature of what it is in the law, you don't have to provide it to everybody if you provide it to one person, because this is what's required by law. So if somebody came in and said, there's just this idea, I suppose, that accommodating people with disabilities in all sorts of settings, including post-secondary education, is lowering standards some way. And that's just not true. It's not what the law says. It's not what the law requires. And I just want to, I don't know, for the people that are here, just want to disabuse you of the notion that this is like lowering standards or somehow giving people special treatment. Okay, next slide. I'm going to talk a little bit more about undue hardship. Um, and I think I like talked a little bit about this already, so I won't belabor it too much. But again, if this is just one way that someone can say that your request is not reasonable and we can't grant it, right? There are some instances where schools can refuse to approve an accommodation or provide an accommodation, and that includes the argument of its undue hardship. Um, yeah, I think I covered that already, so I'm gonna go to the next one,
Okay,
and that's you,
yeah,
Jane.
that's good. Thank you. So what if things don't go though? What if they bring up these defenses as Lawrence described them? What can you do? Like she said, don't stop. That's not, just don't take the answers, don't stop. Because you can try to now engage in the interactive process. So contact the person at school that you set up the accommodation with. Um, Ask them, get involved, find out why these things are happening. And it's a time to use your self-advocacy skills, really, and to advocate for why this works, perhaps you've used it in the past, why it works, it worked for you this way, and just be really aware that the process does not stop there. So that's the internal process, but that would be the way you would first go at it. You can also file a grievance, and under 504 and the ADA, post-secondary institutions have to have a grievance process for students. And so that's still internal. We're not taking it out to an outside arbiter, but we are still at saying, I want to make this more formal. I want to complain on a more formal level. So usually those are written grievances, and there's a process that each university uses to respond to them. Importantly, you should put it in right. If it isn't in writing process, make sure you put it in writing, and just go through the process that they have set up. And again, at the end of that process, it's not the end of your options to fight for what you have asked for. So that you need to be able to, I would suggest, like, if you're going forward this way, write things down and go forward and and let them know, hey, I think I had a case where I said, you were supposed to give me the interactive process. They might not know that, or may pretend they don't know that. So make sure you get them to sit down with you and go through the process of resolving the disagreement about your accommodation. And of course, if you're still having problems, call us. At the end of the line, you can always talk to us, even if you want just advice on the process. We are available.
So what if trying to resolve this through the internal process doesn't work? You've gone as far as you can go with the college or the university, and you feel like your accommodation is still denied, you're not getting your needs met. There are ways to sort of engage outside of the college or the university, if you think a discrimination is occurring. So I'm realizing that this slide's not I'm gonna add something to this slide because I think that the Maine Human Rights Act is missing from
Oh,
it. But let's talk about federal law first, because a failure to accommodate is discrimination. And that's true under both federal and state law. So a Section 504 complaint is a complaint that is filed with a federal agency funding the violator. So if you're going to a college or a university that receives federal funds, like a state school or something like that, you can file directly to the federal government agency that's funding the college or the university. Usually that's going to be the Federal Department of Education. So people can file complaints directly with the funders saying, this you're funding this organization and they're discriminating against me. And they're going to ask for all sorts of evidence, and they're going to make a determination of whether or not they agree. Um, Title II complaints. So that's um, sorry, Section 504, that first bullet point has to do with Section 504 of the Rehab Act. So if you can also, and you can do any or all of these things, if you want to allege discrimination under the ADA, if it's a public university, you can file a complaint with the U.S. Department of Justice or the appropriate federal agency. Possibly that would also be the Department of Education. Title III, which is private colleges, you can file a complaint directly with the U.S. Department of Justice alleging discrimination. You don't have to complete this administrative process before going to court. So you could people can, I'm not saying you directly,
Yeah,
but people can choose to go to court and just file a lawsuit at any time and allege discrimination. Again, all those burdens are going to be there, though. You have to, if you're going to sue somebody or ask for an investigation, you have to sort of prove that discrimination um, has occurred. So you're going to have to prove that you have a disability. You're going to have to prove that you need the accommodation and that the accommodation is reasonable. The other thing that I think that this slide's missing is just there's also the Maine Human Rights Act also has what's called the Maine Human Rights Commission. It's a body of people, it's a group of people that enforce the Maine Human Rights Act. So they have a whole complaint process that's just with the state law where people can file complaints. And they have a website you can Google Maine Human Rights Commission, and it's supposed to be fairly user friendly. So people can also file complaints through the state process. And they'll assign an investigator and they'll produce a report and you can argue if you agree or don't agree with it. And so they can either issue a findings letter, meaning we actually find that discrimination occurred. You can take that letter and you can try to sue. Or they might say that we don't actually agree that discrimination occurred. A person can still sue, but they don't have the benefit of those extra findings. So there are lots of ways, and like Jane said, people can call Disability Rights Maine. We can provide assistance in some way, right? Whether that's just like information or resources. Sometimes we represent people directly. Sometimes our attorneys represent people directly and help people sue or go through the complaint process. So those are some ways to address it.
yeah, and I want to add that these sites have forms. They have ways you can do this. Again, I think, like Lauren said, if you want to call us and see where the form is and how to fill it out and go over maybe some of the information. But generally, these complaint process can be done with you by yourself without an attorney. Again, I think consulting with people is not a bad idea, however, because these are a level up from the internal grievance process. So we're going to end with some self-advocacy advice. I know we got 5 minutes left, and I don't want to spend too much time just on this because I want to make room for questions. So if you have questions, go ahead and pop them in the Q&A and let me go quickly through these slides. Um, self-advocacy, as probably you all know, is a way to get things done that you do. You take it on yourself. So it's a collect. You have skills, you have strategies. You want to communicate what you need. Sometimes you might need a support system, but it's really important to know that should be prepared sometimes. Well, all the time, you should be prepared. You should, in terms of requesting accommodations, you want to be able to have the information of how that would help you. You want to know, you want to be able to communicate in a way that's, we have a whole self-advocacy training that's on our website, but you also want to figure out what the best way it is to communicate this. Should I just go first in writing? Should I ask them for a sit-down meeting? You want to see if you have supports that might be able to help you. Perhaps you have a family member or a friend that's seen how this has worked, so they can give help with providing more information. And you also want to be able to explain what that's going to achieve your accommodation. Not only, is it going to help me do better, or is it going to, just, I think that you really want to focus on the fact that it's going to help me access the class, the course, not so much that it's going to make you do better than anybody else, because that's not what accommodations are for. They are to provide you access to the course. And you want, and sort of some things to prepare before is you need to understand what accommodations will be best for you. You can reach out and document the accommodations. You might look on the internet and have some research done. Follow the procedures. I said that earlier. Make sure you follow deadlines, particularly in the grievance process. I'm sure there'll be deadlines for you to file or appeal. Participate in the interactive process. It says in here possibly with Disability Rights Maine, because we might be able to help you with that process. And advocate for what you need to maintain those accommodations. And again, reach out for help. We're a phone call or website away.